Apparently.
You were like,
Super.
I don't think anything's gonna be done in town.
Good morning, everybody. I'm going to ask the clerk of the Board of Supervisors to call the meeting to order and do the roll call.
okay. Calling the meeting to order at 11:03 a.m. Mr. Yusi,
Present.
Mr. Anand,
Here.
Mr. Armstrong,
Here.
Mr. Bishop,
Here.
Mr. McEnany,
Here.
Ms. Palmer. Here. Mr. Ock,
Here.
Mr. Dion.
Here.
Okay, all are present.
Our temporary chair is still Mr. Usi today or this morning. And with his permission, I'd like to have the board move right to the appointment of a chair and a vice chair. And that would be for the 5 primary members of the board. And typically that's done by way of a motion to nominate an individual.
Can I
So
make a nomination? Mr. Yusi, please.
I'll second it.
any other nominations for chairperson for the Board of Ethics? Oh. Seeing no other nominations. I'm going to ask the clerk to, as the attorney, I'm not sure I should necessarily run the process, but I'm going to ask Ms. Allen to move forward with the voting.
Okay. There are no other nominations for chair. Seeing none, we'll close the nominations. Are all in favor of Mr. Yusi for chair of the Board of Ethics? Please say aye.
Aye.
Are there any opposed? Mr. Yusi, you are now the chair.
Well, thank you.
Congratulations.
I think so, Bob.
Well, it's the first time anybody's clapped for me in a long time.
Mr. Yusi, would you like to move forward to receive nominations for a vice chair?
I would. And I would like to nominate Ash for vice chair.
I'll second that.
Any discussion? All in favor, say aye.
Aye.
Anyone opposed? Thank you, Ash.
Thank you.
Congratulations.
Thank you.
With that said, moving on to public comment. I request to hear if there's any public comment at this point. Hearing none, then I would turn it over to the county attorney for his presentation and overview on the standing rules and procedures.
Thank you very much. We did distribute and we did post for public review draft standing rules and procedures for the Warren County Board of Ethics. As just as a preliminary matter, was everyone able to receive those emails?
Yes.
Okay, I know they did go out to the county email addresses. I would remind and ask every member to try your best to stay in tune to checking that email. It may not be your primary email, but just to ensure that there's nothing that's going out to you for your review on a somewhat regular basis, or checking to make sure there's whether there's been something sent out for your review would be tremendously helpful. I've also been told to let each of the members know that in the next few days, you will be receiving an email at that county email address. And it will provide the information and link that you need to complete the annual training requirement that you're now under as appointed members to the board. It's the same training that all county employees are required to complete in the first 30 days of January.
Just want to ask if I've don't know how to access that email.
Okay. At the end of the meeting, if you'll wait, and then I'll make sure I can connect you up with the IT department to make sure that happens.
I gave him my phone number, so I don't know if it's just a text message we're supposed to get.
I believe there was a authentication that needed to occur through a cell phone number, but I'll give you that information and you can follow up directly with them. And then the only other reminder is to pull and review the code to include the financial disclosure statement that's present as an attachment to the code. I would ask each of you as soon as you're able to print that, complete it fully, and then file it with the county attorney's office. All filers are required in Warren County to have their financial disclosure statement filed by the last day of January.
Mr. Elman, are we doing it digitally this year at all, or?
No.
No.
And with those said, I guess we'll move right on then. Everyone should have a copy of the proposed rules. They're long and they're detailed. Because there's really no process or procedure provided for this board by the Code of Ethics. So what I'd like to do is, I'm not going to go through every single item on every single page, but I'd like to approach them in groups. And as any member may have a question, concern, complaint, suggestion to modify or amend, let's go through it as we go through each of those sections. It's probably the best way, rather than me just talking through it for 20 or 30 minutes. Any questions before we start about anything I'm able to answer? So the first section is really just the conduct of meetings and trying to capture some of the basic rules and requirements. The board will be meeting here, most likely in this room. And we do need a quorum, a majority of the whole number of the primary members, which is a fancy way of saying 3 out of 5. Given that we have 3 alternates, my hope is we'll always have a full board of 5 when we meet. But if we're unable to do that, we at a minimum, in order to proceed, we have to have 3 members present. And then that also will tie into the voting by the primary members or the alternates that are acting as a primary on a particular meeting. The schedule for board meetings will be set by the chairperson of the board. And my hope is that if you're a primary or an alternate and you're not able to make a meeting, let us know. Especially if you're a primary, so we can make sure that the alternate members are prepared and ready to go forward at the meeting when a primary member is not available. All of our meetings are defined as under the open meetings law, and that's as a result of the Code of Ethics. So for that reason, this meeting and all future meetings will be recorded and are live telecast. They'll be saved on YouTube for members of the community to review going into the future. A lot of the procedural stuff about posting meetings and posting materials, the staff here at the county, which will be either myself or the clerk of the board, will handle. One important rule under N, which I've kind of stated, but just so everyone can see it, is that all actions and decisions that are taken by the board may only move forward or occur by a majority vote, which again is 3 out of 5 members. And then we will work with the chairperson to file a statement with the county clerk's office that will appoint the Warren County attorney or designate the Warren County attorney as the custodian of records for the financial disclosure statements, which will start coming in over the next couple of weeks. And then the last rule is that these rules can be changed at any time by the board should a majority of the primary members vote for that modification or change. I don't know, anticipate, or expect that the rules as drafted, if they're enacted as drafted today by the board, work 100% in every circumstance, meaning as the board works together, you may find certain ways of doing business or processes are easier than what's in these rules, or maybe the rules don't address something that needs to be addressed. Under those circumstances, on a motion that's approved and voted by three of the 5 members, or a minimum of 3 members, the rules can be modified and changed at any time. So hopefully that will occur, because that means we're learning and growing into a process and a procedure that's going to be more responsive and just flow better for everybody involved. That's also my disclaimer.
I've got a question on N. Is that a majority of present board members or the board members? So in other words, if only 3 members show, is that the majority 2, or is it?
That's an excellent
Because-
question. Yeah, that's an excellent question. All votes will require 3 members. So if there's 3 members present for a meeting and there's something that's being voted on, all 3 members would have to vote in favor of the motion or item that's being voted upon or approved.
Now, would that include if an alternate is filling in for a primary? and
Yes.
Also votes.
Yeah, it's always 3 to pass.
Okay.
So just to give an example, so 3 primary members make it to the meeting. 2 alternates fill in for the 2 primaries that couldn't be there. That's a 5-member board. That's making a determination. At least 3 of the 5 members need to vote in favor of the matter that's being considered by the board. Same holds through if no primary members show up, all 3 alternates are sitting. Those 3 alternates, as the only members of the board, all need to vote in favor of anything that's going to be passed by the board that day. So it's great that we have 3 alternates, because it helps having a full 5 members present, which from my perspective will hopefully help the conversation on the issues that the board will be focusing on, because you have more individuals from more different backgrounds and varied backgrounds having the conversations necessary to come to a determination or a decision. Good question. Thank you. Section 2 is service of documents. That's just technical. And that's there so that we have a way as a board to know that individuals who are engaging with the board, or who the board is reaching out to engage with under the code, are actually getting notice of what's occurring and the method that that's going to occur. So basically, it's they're either being handed the documents that are being served on them, they're being provided by email as an attachment, or the last alternative would be regular mail to the home address on record with the county. Would be the 3 types of service that would be available. And then there would be a proof of service form, which is one of the attachments to the rules that would be completed anytime a more formal document was served on a county at the request or the requirement of this board. Number 3 is starting into one of those core areas of responsibility for this board, which is the annual review of the financial disclosure statements. But the way the code is written, this board needs to have an initial meeting each year on or before February 14th. And the purpose of that meeting is to conduct an initial review of the financial disclosure statements that have been filed by the mandatory filers for that year. By April 1st, there would be a final review of the financial disclosure statements for the current calendar year. And the board will verify whether or not all of the mandatory filers have filed. Process-wise, procedure-wise, my office will assist in the administrative aspect of who did we receive a document from, who we didn't receive a document from, organizing those and providing them to the board in some intelligent format so the board can review them. As the members who were on the board previously can attest to, it's a lot of paper and a lot of paperwork that comes in. So the core piece is ensuring one, that initial review before February 14th, and then by the end of March, that the financial disclosure statements have all been reviewed so that there could be a representation or an acknowledgement that the board is satisfied with the statements that were received. Which leads us really into what the rest of this section is about, which is what do you do when one of two things happen? One, you don't get, or a financial disclosure statement is not filed by a particular employee, or what the board receives and reviews they're not satisfied with, or they feel is lacking in some material important way. So the first step really under 3D, on or after February 1st, which is after the due date of January 31st, the board would identify those mandatory filers who didn't file. And then the chairperson would be directed to issue the failure to file notification to those individual filers, with the form for that enclosed at attachment B. My goal was to try to create a process that would be easy to implement so that we wouldn't have to create individualized documents at every single step in the process for these, which is why that exhibit, that attachment B document is there for your review, consideration, and approval as part of the rules, as well as the other attachments that we'll go through. Basically, that goes out. They'll have 14 days after the notification goes out to file their disclosure. And if they are not filing it, there will also be a date and time for them to appear in front of the board to explain why they're not filing their financial disclosure statement within that 14-day window. And if a majority vote of the board determines that the failure, that the filer fails to appear at the board meeting, then the board may refer that individual filer for potential disciplinary action to wherever in the chain of employment or chain of command and authority that filer would fall, whether he works underneath a department head, reports to the county administrator, or reports to the board of supervisors, or is a member of the board of supervisors. The board can grant on a case-by-case basis extensions of time to file for good cause. Often what will happen is if there's an employee who's out for a leave of absence for a medical reason or for some other purpose and is required to file but physically unable, that information will come to my office. We'll present it to the board so the board can delay or grant an extension of time as the situation may require.
I have a question.
Yes,
On these reviews, can you just define what you mean by review, meaning is it going to be presented to us individually, say via email, where we will review those? and Raise questions, or is it as a committee, review them one by one?
Great.
What does that review? What does that mean?
Great question. I'm going to start with F and then I'm going to go right to your question,
Okay,
right? So I want to talk first about what you're doing in that review process.
Okay.
And the intention of the thought is that you're reviewing to make sure it's on its face sufficient. You're not necessarily trying to verify the truthfulness and accuracy of the information that's being provided. But on the face of the document, was it fully completed? And does it appear that the information was that the form was fully filled out and submitted to the board? I suggest, and I focus on the word suggest, I suggest gently to the board that if the board's not going to be in a position to try to verify the individual entries that any employee or mandatory filer makes on the form. The key piece is that the employee mandatory filer has identified potential conflicts that may exist as those disclosures are required under the Code of Ethics. So what is that? Let me break that statement down as I understand it. All of the authority, the starting point is always, what's the authority of the board? And the authority of this board is outlined, provided, and limited to what the Board of Ethics states this board can and cannot do. In there's a great amount of discretion given to the board regarding the procedures the board uses, because the code does not lay out really the process. So when we talk about the review of the content of the document, that somewhat is governed by the code, meaning what the expectation of the code is for a filer to put in their form. But the particular question of how to do that and what that looks like, that's going to be up to the board. So last year, we attempted to print out hard copies in binders for the members of the board to review while here. The financial disclosure statements are considered a confidential document. The access to them are limited. They can be subject to FOIL. But my office attempts as the custodian to ensure that they're safeguarded, I guess is the best way to put it. So last year we did the photocopying process in binders to help ensure the confidentiality of the documents, because once a document goes out by email, it's out there. That doesn't mean that's the right way. That doesn't mean that's the way this board wants to do it going forward, but I think that's a great discussion for the board to have going into this review process in early February. I don't know that it has to be figured out today, but it's certainly coming up pretty quick. And the method that the board wants to use and votes to use or decides to use is what my office will prepare for and then use. So how was that? I feel like I didn't completely answer the question because I don't know what the answer is going to be until this board decides collectively on how they want to go forward.
is now the time to have that discussion, or you want to finish your presentation?
Well, let's go through all of these rules and see what questions we have, and then we can kind of take it from there. Because that question, the question of delivery of documents is going to come up again and again and again under each of these sections. So what does it mean to be facially sufficient? The rules are proposing if a reasonable person reviews that document, do they have a concern that any of the answers were not responsive to the questions asked? So it's kind of that, it's reasonable person is just kind of the common sense. What the average person would think if they're reviewing the document, does it look like it's complete? Or does it look like it's just not complete? And depending on the answer, depends on whether or not the process gets triggered to have the employee or the mandatory filer refile or fill in particular questions that were not fully responded to based on the review by this board. So the board, like I said, can either return to the filer and demand a more complete response, request the filer to submit a new disclosure statement, direct the filer to submit any supporting documentation that would address the concern that the board has observed or seen in that initial review. And or the last step, and I'm on the top of page 6 now under it would be H sub 4. Request the personal appearance of the filer before the board to answer questions concerning the information that was contained in the financial disclosure statement. So it's a stepped up process, starting with the most gentle response, which is, hey, fill in what you didn't fill in, leading up at the end to it's now we think it's collectively, we believe it's time for you to come in and actually address why you left your entire form blank or whatever the case might be. Under I would be corrective action. And there's a form again to do that. The first form would be for the first time they're notified that the information is not complete. And then there would be additional notifications if they continue to fail to complete the process that's required. That ends with this board not doing it again and again and again, but moving and giving notice then to the appropriate parties, which would be the clerk of the Board of Supervisors. So the clerk can publish to the Board of Supervisors, the county administrator, and the county attorney. In the case of an elected officer who's not complying, that they're not getting compliance with the requirement to file a complete financial disclosure. And if it's a non-elected county officer or employee, depending on who the person is, they would be their department head or the county administrator for corrective action. Because what you're doing in that case is, in effect, you're going back to the statement I made at our first meeting, is that the board has powers that are advisory only. And in that case, you're making the determination that that individual filer has repeatedly failed to meet the obligation to file a complete statement. And you're referring it to the appropriate body or person to review for any potential disciplinary action on that employee. My hope is we never get to that portion of the rules, but in order to be complete, should the board find themselves in that situation, that's really the last step, because then it's up to the supervisor or the Board of Supervisors to address the situation. Any questions on filing of financial disclosure statements?
What kind of a problem has this been in the past? And how many employees, relative number of employees, does this financial?
Apply to? Two good questions. I can't address prior to last year for two reasons. One, I didn't start as county attorney till November of 21, so just over a year ago. But more importantly, I don't believe, well, I'll be as blunt as I can because I know I have been with the past board as well. It's my understanding that prior to 2021, individuals who were required to file these statements submitted them in sealed envelopes. and the sealed envelopes were never opened. So this code and the code that came into effect for 2021 really was, in my opinion, a sea change, where now there's a process and a procedure and a directive that the Board of Ethics is actively required to look at them when they come in. How many, I can't tell you off the top of my head. I don't want to venture a guess either. But there is a list of the positions in the code. I believe it's attachment A. So when you look at the code, it's right before you'll see I believe it's the first attachment or the second attachment before the financial disclosure statement, which each of you will be filling out. Thank you. So if there's no other questions, we can talk about the next number 4 issue, ethics advisory opinions.
Mr. Alman, can I go back to that bit? Sorry.
Sure.
One is 3D mentions on or after Feb 1, people to identify which ones have not filed. So do we have a reporting structure in place of how will we get that information of how many have not filed?
My office will be logging in and recording and date stamping the statements as we receive them.
So my assumption is that we will get some kind of information in terms of how many were sent out and how many we received.
There'll be a meeting at some point after February 1st that gives us enough time to make sure we have it correct. And there'll be we'll be able to provide the names of individuals who have not filed at that point.
Okay, and then these have been sent out to all employees as of right now, the forms.
We don't send out forms to employees. Employees know who they are by their position that they need to fill. The county administrator's office may be sending an email, a reminder. But part of being in the position that you're in is to know that you have an ethical obligation to fill out the form because you are serving in the type of position that can create an ethical conflict, meaning you're involved in the decision-making process in a manner that could create a conflict.
Thank you.
Larry, I can say in the past that reminders were sent out. I don't know what the practice will be this year.
Last year, they were not.
We're not.
Years before, I believe they were. Or if there was a reminder, it came from the county administrator's office. So we'll check on that and follow up. I think there may be something that's going out, but sitting here today, I'm not 100% clear on when that will be or what it's going to look like. All right, the second area, ethics advisory opinions. Any officer or employee of the county can submit a written request for an advisory opinion. And because it's an advisory opinion, it's about some planned or potential future conduct that the officer or employee believes they will be taking. Once again, there's a form that's provided for that individual to use to request the advisory opinion. The board would treat that as confidential. But the requesting party understands that anything submitted in writing may be disclosed to the public under the Freedom of Information Act or otherwise. And the process would be is when my office would be the custodian of those requests. When my office receives one care of the Board of Ethics or for the Board of Ethics, we would advise the chairperson. And then at that point, the board would determine what to do. With the first decision to be whether or not it's a request for an opinion that the board feels is appropriate or necessary to respond to. And if it is appropriate and necessary to respond to, what steps will the board take to investigate, conduct fact finding, background research to include legal research, and then reviewing policies and procedures of the county. And the legal counsel for the board would assist the Board of Ethics in completing those tasks. So if the board decides by majority of vote that they're going to review and issue an opinion. Really, the first thing is the board's deciding is the request within the jurisdiction. So is what they're looking for an opinion on within the scope of the Code of Ethics? And then necessarily within Article 18 of the General Municipal Law, which we discussed at the last meeting. If no action is going to be taken, then the chair will issue a letter letting the requester know that there's not going to be any action taken on the request. If the board believes it's within the jurisdiction and the request provides enough factual information and it's not hypothetical, but real in nature, meaning it's something that is likely to occur in the future, then the board would determine if the opinion would help guide that person's future conduct. If the board has issued any opinions previously on that topic. Is the matter being investigated by law enforcement? Because that would be a factor the board may not want to then involve themselves in if there's a law enforcement investigation occurring. And and then the last one would be, is there a conflict of interest by the board that would require recusal by any of the board members on that request? If the board decides to issue an opinion, a case number will get assigned to it. And then the goal that I recommend is 90 days. 90 days for the board to investigate, prepare, review, and approve by majority vote an advisory opinion. And the reason I say 90 days is because if the board is unable to come to a collective position within 3 months, meaning 3 of the 5 members agree on the answer on that advisory opinion, if you can't do that, then that seems like an appropriate time to let the person who requested it know that you're not going to get an advisory opinion from the board because the members can't agree on it. Again, I don't know that that would ever happen, but that would prevent some potential opinion from going on from meeting to meeting to meeting to meeting without ever getting resolved. The opinions, once approved, would go to the clerk of the Board of Supervisors to be distributed to the Board of Supervisors, County Administrator, and County Attorney. And so long as the person who requests the advisory opinion and then receives the advisory opinion acts and follows what the board says, the board won't take or review any future ethical action against that individual, so long as they followed the recommendations that were made by the advisory opinion. Basically, it's like a safe harbor. That's the concept here. They're not sure they should be doing something or not do something. They ask for an opinion, you give that opinion, and then they follow it. They're not going to be in harm's way by the board for following the opinion that you gave. Questions, thoughts? I'm grateful that at the end of this meeting, I'll be speaking so much less because this is almost like coming up here. I was thinking of this as like day 2 of orientation in a way. And once we're through it, you guys are in charge. You're in charge already, but I don't know that I have much speaking that I'll be needing to do, I hope, in the future. The next area on the procedure is the complaint process. The board's authorized to accept a written sworn complaint that has an original signature. That does require that the person filing a complaint submit an original document to the board. Emails, facsimiles, however else documents might be conveyed. are not going to be accepted. And the form that's provided also has attached the certification language that false statements that are made on the document are punishable as a Class A misdemeanor pursuant to the penal law, which is important so that individuals who are filing a complaint are aware that making a false statement and knowingly making a false statement and then submitting it to the board could be punished by a criminal prosecution. Subsection C, no member of this board, the county or the county attorney's office will provide any assistance or advice to a complainant who's preparing a sworn statement to submit to the board. Any person can file a complaint. I guess that's just to pull back to the code. So unlike an advisory opinion, which is limited to officers and employees, any member of the public is allowed to file a complaint so long as it meets the procedural requirements, that it's written, that it's signed, that it's notarized, that it has the certification language, and that the original is provided to the county attorney's office. So in order for this board to then determine that the document that's submitted is in fact an ethics complaint, it must under D meet the following. It must have the full legal name of the person or people who are the subject of the complaint. To the degree possible, their department, position, duties, and responsibilities. Must also have the date, time, location of the alleged ethics violation to the degree possible. A detailed description of the facts that are known to the person who's filing the complaint or discovered by them. Any affiliation or associations or relationships that the person has to the subject of the document that they're filing, that they're complaining about or claiming committed an ethical violation. The complainant's full legal name and contact information. And then any supporting information or documents that that person possesses regarding the claims they're making in the ethical complaint. The reason that completeness is required because the board will then render a preliminary review of the document. And if it doesn't comply with the rules, the document's going to be sent back to the person who filed it. If the document complies with the rules under F, then it'll get a matter number. And the board will move into the process of determining what, if any, action the board's going to take on that filed document under G. So the board will determine if the document is in fact constituting an ethical complaint based on the factual information that's provided to you and the attachments that are provided. And really the focus is whether it's both credible and actionable information. Is there a specific provision of the code or Article 18 that's alleged to have been violated? Or can the board, looking at the facts, clearly determine and identify what the allegation is of what was violated under the Code of Ethics? And do the factual allegations establish a reasonable cause that an officer or employee violated a specific provision of the code or Article 18? So reasonable cause would be that the information that you've received appears reliable and discloses facts and circumstances which together convince you that it's reasonably likely, not that it happened, not that it's proven to be true, but there's sufficient information there for you to believe that there was an ethical violation just based on the complaint and the information that's provided. That's a case-by-case review that the board will do. And if the board finds or fails to vote that there's reasonable cause and all of these requirements exist and have met, then the board will vote not to take action. And in effect, really, you're voting that there's not enough to go forward on it. And the chairperson will notify in writing with the assistance of the county attorney's office by mail, the person who filed the complaint that no further action is going to be taken. V, the board, the last section there is the board shall not disclose the existence of a filed document which was not deemed to constitute a complaint to any person absent compulsion of process or an order of the court. So the theory and the concept and the process here is the board receives a document that's filed that claims that it's an ethical complaint. You go through the review process. It names one person, 5 people, or 10 people, however many, of committing these egregious ethical violations. But when the board reviews it in this process, you determine, no, it's not. So the concept here and the process would be that that document and that information doesn't become public in any way unless and until the board makes some determination that, one, it qualifies as an ethics complaint, and 2, the board's going to move forward and do some next step with it to investigate it. It's possible that this board will receive documents that are filed with the county attorney's office at some point, which claim to be a complaint against particular individuals, but upon review, you may find that there's nothing there. In that case, the recommendation is we try to protect the individuals who may be named in a complaint, in a document that's filed, until this board reviews it and determines that in fact there is something here that needs to be investigated. So I just wanted to pause and take a break on that point, because that's a big point, and I don't want to gloss over it. And it's really kind of a balancing that's being recommended here of protecting individuals from unwarranted scrutiny or claims until the board says, yeah, there needs to be scrutiny regarding these claims. So if there's any questions, comments, this would be a great time for me to stop talking.
I assume all this is done in executive session, correct?
That's a great question, and I'm not 100% clear on the answer. That's going to be up to the board. All of these meetings are open meetings, so the board may make a motion to go into an executive session to address a particular matter where there's an exception to the open meetings law. And we did talk about that a little bit last time, and we can talk about that again. I would encourage the board to consider those motions when we're looking at documents that are claiming to be complaints, and as the board is formulating whether the documents meet those requirements and whether they're going to move forward into the investigation of a document that they deem to be a complaint. Because doing it in executive session really is probably the fairest to all the parties, the person who filed it, as well as the people who are named in it.
I have a related question. So under the open meetings law, we are not required to publish or talk about all the complaints received. That is discussed by the board first, and then we determine if they are to be actioned. Asking because what happens if there is, as of 5H3, there is a complaint that is confidential and could affect somebody's employment. I know it can be discussed case by case basis if they need to be proceeded with in an executive session, but are the complaints subject to be public information?
Let me phrase it this way, and this is my legal hat firmly affixed to my head. The county attorney's office receives these documents. That's who they come to. I, as the county attorney, and my staff make no determinations, decisions, judgments about the documents that are received. That's solely the job of the board. The board can't make that determination of what it is they've received until they review it. So in essence, the board's not reviewing a complaint. It's reviewing documents that were filed with the county attorney's office to determine if what was filed and received constitutes an ethical complaint that the board is going to take action on. So up until the board has a chance to review those documents, they're just there's no classification to them. There's nothing that's happened to them, and it's the board that will then make a determination of what is it and what, if anything, are we going to do next with it. And it's at that point that you move to H, which is really what do we do with something once we feel if it's once we determine if it's an ethics complaint and it requires further investigation. Does that help a little bit? Like, so for example, person A files with my office documents. And person A says, this is an ethics complaint. I want it investigated against, these individuals. It's just documents until it comes to this board at a meeting, which can occur, and I would recommend occur in executive session, to review the documents, to make the determination if it meets the requirements. And if it meets the requirements, then it becomes an ethics complaint. And then we move into a much more different process. If it doesn't, then the chair notifies the person that person A, that no action is going to be taken on the documents you submitted. Thank you for submitting them. If it is deemed to be an ethics complaint, then steps need to be taken that this board will decide. And that's where the whole concept of due process, making sure any individuals who are named in that document now know about it, have an opportunity to review it, or at least know its contents and respond to it. And the concept under these rules is really kind of just like a series of step-ups at that point. So once you've moved through and you have, so person A files these documents, the board reviews it, and they're like, yeah, this is definitely an ethics complaint. It meets all those requirements. We have reasonable cause to believe it alleges a violation of a particular section by a particular person. Then we start the process of that step up. And at any point in those actions, as you step up through the investigation process, built in is a decision-making process as well, where you say, we're satisfied now that there was no violation, so we're closing it, or we're not satisfied now, and we still have questions and concerns, and we're going to move on to the next step in that process.
So to clarify for me a little bit, Mr. Ullman, what you're saying is that if you receive an ethics complaint, you will be presenting it to the Board of Ethics for review, and that review should take place in an executive session to provide confidentiality of the individuals named in the complaint until a determination whether it has validity or not to move it forward. Is that what I'm hearing?
Kind of, but I'm going to have to be more exact. When my office receives documents, we're not in a position to say it's an ethics complaint. The person may be claiming it's an ethics complaint, but that's a determination that's only made by this board. So those filed documents will be presented to the board. The board may make a motion to go into executive session to discuss those documents, the individual who filed it, the information that's provided, and the individuals who are named for allegedly committing the ethics violation. It's my recommendation that the board consider doing that because it does protect all of those parties.
Right.
from unwarranted public view, which would have to happen in an open meeting.
Right.
And hopefully at the end of that executive session, when you come out, the board can then take a vote and determine whether those documents constitute an ethics complaint, which the board will take action on or move forward on, or that the board's not going to take any further action on those documents.
Thank you. That does clarify it for me. Also, one other follow-up question, Mr. Ullman, is that are these documents, regardless of whether they were discussed in an executive session or in a full board session, are they subject to FOIL?
Every record is subject to FOIL. The issue is, and it's separate and apart from this board, what decision the record access officer makes regarding a particular FOIL request regarding release of particular documents. So in essence, it's not really something this board the FOIL aspects of it, the board doesn't have to worry about because no member of the board nor any member of my office has the ability to release any documents on our own. It's only the record access officer, who's the county administrator currently, has that authority after applying the rules and the exceptions that may or may not apply.
All right, thank you.
In review, I'm looking on page 11, the up middle of the page. I think correct me if I'm wrong, I think you have to go into executive session until it's determined if there's a ethics violation, because we are compelled by that paragraph not to disclose anything if it is found not an ethics violation. So until you determine that, I think you have to be in executive session.
Yep, and the problem is with the way I drafted that section, because I made an assumption that's not true, and I made an assumption that the board will always go into executive session. Truth is, only the board can make that determination. There's my understanding of the open meetings law is a board cannot be compelled a board cannot be compelled when they're going to go into executive session or not to address an issue. But I think that was very insightful, and I'm going to have to tweak that language slightly.
So Mr. Alvin, there are 2 points here, right? So from a qualification standpoint of a complaint, one is to determine if the complaint is in fact an ethics complaint. And second is if it is an ethics complaint and it has to be kept confidential because of the nature of the complaint. Now, both will be, in my assumption, addressed at that executive session before we take the matters further.
Well, that section V that we're referring to, where it says the board shall not disclose the existence of a filed document which was not deemed to constitute a complaint. The purpose of that was really kind of an after the fact, meaning the board's decided that these documents aren't a ethics complaint. And we want to protect and ensure that those documents don't just go out to the public, or the information in those documents don't just go out. I mean, that's the core of the trust that's placed in each of you as members of the Board of Ethics, is that ethically you're going to ensure that the information that you see, whatever it is, remains confidential when it's supposed to remain confidential. And I off the top of my head, and that's kind of a disclaimer, off the top of my head, I think everything remains confidential more or less, or at least that would be my hope for this board, until there's a vote that it's not. Meaning there's a decision, there's a advisory opinion, there's some affirmative action that the board has had a meeting of the minds on. Well, at that point, yeah, that's when it becomes public. And that's not really hard and fast. That's kind of more of a aspiration, I guess. That the board consistently keeps in mind the balancing of interests between the public interest, the filer, the complainant's interest or the person who filed its interest, and then those individuals who are named in that complaint and their interests as well. Okay, so complaint review process under H. This only kicks in once the board has made that initial determination that the documents that were received are an ethics complaint. Within 5 days, the board's going to issue a notice of complaint to the respondents. The respondents are the individuals the board identifies as being the subject of the complaint. And the board will determine, I mean, there'll be a general statement of the facts that's provided, the code that's involved, and the board will determine on a case-by-case basis by majority vote whether to include and disclose a copy of the complaint with the notice. And it lists all the different factors that the board should consider in making that determination. And at the very end, the last determination will hopefully be the one that the board members keep first in your minds, which is the concepts of due process and ensuring that the individual who's named, the respondent, is receiving not just notice, but a full and fair opportunity to be heard regarding the allegations and able to answer and defend themselves from those allegations now that the board has made that step in saying that the documents are in fact an ethics complaint. Once that notice goes out, the respondent would have 21 days to file an answer, which is really a sworn affidavit, and any supporting documentation that they may have in response to the notice of complaint. And there's a proposed attachment F to assist the respondent in what that should look like. Once the board receives the answer, which is the sworn affidavit, the board can conduct what's called an informal investigation, which is really fact gathering, and evidence gathering to assist the board to evaluate the complaint in light of what was in the answer that was provided. I put this forward for the board to make a determination by vote whether one or more individuals should be assigned to do this informal investigation. It's a little unwieldy potentially for 5 primary members to do it. One gentle suggestion is it would be potentially, when we hit that phase, something to consider not just primary members, but alternate members as available for assisting in, to give alternate members a little more direct involvement in the working of the board. But again, that's what I call it, just a gentle suggestion or an idea. And then the results of that informal investigation will get reported back to the board at the next scheduled meeting that's going to address the complaint. And you got, as a board or as designated members doing the investigation, you can do written demands for information from individuals, whether it's the person who filed the complaint or the respondents during this phase. You can also serve a written demand on any county officer or employee for information because they're within the scope of needing to respond. And then third, you can request, you can't really demand, but you can request additional information from outside third parties who are not county officers or employees. But that would be at their discretion whether they would answer or provide the information that you're seeking. Now, at that point, we're up to I, actions available to the board. So now the board has gotten documents, they've said it's a complaint, they've put the respondent on notice, the respondent has been able to respond and provide an answer. And the board has been able to go and do any fact finding or evidence collection that they think is appropriate. So we're at the phase now where the board would determine at this point, is there still reasonable cause to believe that there's an ethics complaint, or has the board successfully, through this informal investigation process, been able to determine that no, we no longer think that there's an ethical violation based on what we now have in front of us? So that's, again, we're talking, when I talk about steps, we're at that next step. And the goal is to determine, are we good? Is there enough here, or do we have bigger concerns or unanswered questions still? If the board determines at that point by a vote that there's no longer a reasonable cause to believe there's a violation, then the board would conclude the investigation, dismiss the complaint, close the matter, and notify the parties through the chairperson in writing that that was the decision that has occurred. If the board determines that they still believe there's potentially, you're not making a you could make a final determination at that point. I guess that would be a case by case basis, depending on what's in front of you. Because it's always possible that it's not being I want to say contended, but there's really no contest from the respondent that they did the conduct that's being alleged. So it's always possible that at that point, there's really no need to go further because it's been established that there's been an ethical violation. But if it's not that clear cut and there's still a need for more investigation, then there's this procedure, which is an investigation hearing procedure, which is really the last step and the highest step, which would require the most due process. And the recommended rules really, one, you would look at it and determine first, is the respondent somebody who falls under section 75, meaning are they an employee who has section 75 rights, which is the procedure and process used to terminate employment or to take any other discipline that's less than employment termination against an employee? Because the board would first make a determination if this is something that should be referred right now out to the supervisor, the county administrator, and or the board of supervisors for disciplinary action. If not, then the board would move forward with scheduling a hearing date and time, issue a notice to appear to the complainant, the respondent, or any other county or officer or employee that you seek to question. The questioning is informal in nature, which means it's unsworn. You're not placing individuals under oath, and you're not recording it or taking a word for word transcript of what they state. The reasons I recommend that is because this board only makes advisory opinions. And this board does not have the authority under the code to discipline any individual or respondent for conduct. You can only make a recommendation. So to comply with due process and to make the process move somewhat smoother, doing an investigative hearing rather than an evidentiary hearing where people would potentially all receive attorneys and verbatim transcripts would be taken of all the words said and formal findings drafted and prepared. It's more in line with the advisory nature of this board if there's a need to go to this last step in the process. The notice to appear would give 14 days notice. It would provide the information that's listed there. Any witness, to include the respondent, has the right to appear with an attorney, but the attorney is not given a role in the proceedings other than the right to advise their client, whether it's a witness or a respondent during the course of the proceedings. Or, as I've already covered, that there is no administration of an oath or an affirmation before the questioning. There's no legal right for the complainant or the respondent to be physically present during any portion of the investigation hearing. That's a determination that would be made by the board depending on the case, the facts, and the individual that's being questioned by a majority vote. And while there's no requirement for the board to record any unsworn testimony, the board may, in a particular case, decide to create a record of all the questions and answers posed to a particular witness, depending on the facts and circumstances. If you do that, you would need to maintain that record for 3 years from the date of any final employment action that may be taken against any particular respondent or otherwise under state law.
Mr. Elman, is that hearing subject also to the open meetings law?
That would be determined based on the bases for executive session. And it could be determined on a witness by witness basis or as a whole. I can't give unlike what I spoke about in the very beginning of the process with filed documents, I can't give a general, it should apply in all case legal recommendation. It's going to depend on the situation, the case, the charges, the facts, the person. But what's consistent is this board makes that determination.
Thank you.
After that investigation hearing is completed, the board may now determine that they don't have a sufficient basis to find that there was a violation of the code, in which case a notice of disposition would be issued and the matter would be dismissed and closed. If a majority of the board believes that there was a violation of the code, the board will prepare what's called the advisory decision. Once that's approved by a majority vote, a copy of that would be served on the respondent. And it would also be served, again, depending on the individual's position, a series of different parties as set forth, whether they're employee, officer, or elected official. Now, as part of that advisory decision, the board may, but it doesn't need to, also make an advisory opinion on enforcement, meaning what is the appropriate action or discipline that you're recommending based on the investigation that the board has completed. The only time the board can do that is at the same time that they're issuing the advisory opinion on the underlying merits.
What if you can't determine? In other words, let's say you can't get the appropriate, you don't have subpoena power, okay? And say a key party, say I was reading in there about the ticket, $75 is the maximum ticket to a. And somebody got to go see Taylor Swift at some convention, whatever, somebody gave him $1,000.
Mhm.
But that entity, because you don't have subpoena power, will not comply with your request to show up at the hearing. So you can't determine whether in fact concrete wise that ticket was given or taken. I didn't see anything in here where you really can't determine it. What do you do?
No determination is a determination. Because the only time you're issuing an advisory opinion or an advisory opinion or an advisory decision, I'm sorry, or a advisory opinion on enforcement is when 3 of the 5 primary members all agree. So you may have that decision that goes to the weight and sufficiency of the evidence, which is just a way of saying, what did we receive and how much weight do we put in each individual piece to get us to where we need to be to find a violation of the code? Yeah, there's no answer, and it's not a perfect system because there is no subpoena power for this
No.
board.
I didn't know if we make the recommendation to go to a next level. That's what I mean. Because we don't have the ability to get the right information.
I believe that's appropriate under these rules.
Okay.
I don't know that I specifically thought about the situation where you don't have enough.
Or somebody's not.
Yeah, because
Why?
you probably haven't gone all the way to the end of the process because that's the kind of thing that's coming early.
Because we can't compel somebody to give us information other than request.
Who's not a county employee or officer. Yeah, that's correct. That's correct. And then the last section in there is that the board may, doesn't say must, but may publish on their webpage any advisory decision issued by the board to include any advisory opinion on enforcement upon the majority vote of the board. Right, but that's the case that's really run all the way, you've run the case all the way through to the end at that point. And then section F is just highlighting that the attachments in publication, the attachments that are part of this are all part of the standing rules as well and approved by the board. Questions, thoughts? The board, if the board can do one of 2 things at this point. There can be a motion to approve these, and then they will become the standing rules moving forward. Or the board can make a decision to delay a decision until the next meeting to move forward on these rules. The only practical impact of adjourning for a final vote on these rules and not voting today is it may slow the process of starting to review some of the filed documents my office has been holding for months. But at this point, I want to make sure that the board understands and is comfortable with the process and procedure that's being proposed. So whether you move forward on it today or wait until the next scheduled meeting, I kind of defer to your judgment.
Larry, with respect to the rules and amendments at different times when we actually work through the process of going through complaints, there's going to be different questions and things are going to come up and there may be needs to or thoughts to amend the rules at different times. That can happen anytime. Proposals
Absolutely.
do that. And my other question is, the rules of this committee, are they established in the resolution by the Board of Supervisors with respect to that? So that's controlled by this board here.
Yes.
With respect to the current rules that you provided for, you indicated that there may be some tweaks about the open meeting provisions. Is that something that we can deal with at this point? Or is that something you would put that into writing?
I'm not sure what tweaks that would be. I mean, the open meetings law really, it's going to apply in the individual circumstances. We can't change the open meetings law.
I know we had some discussion regarding going into executive session and those type of.
It's honestly a decision the board has to make on motion each time it comes up. The question, I think, let me find it. The one open question I had, or that was presented, was on page 11 under G V, which is in the middle of the page. That says, and I'll wait till everybody can get there. It says the board shall not disclose the existence of a filed document which was not deemed to constitute a complaint to any person absent compulsion of process or order of court. And that does conflict, that's not as clear as it should be. The intent behind there was if the board determines that some filed documents are not a complaint, you're not going to disclose that. So I guess I'd recommend that it say upon the board. Let me just write it out and then I'll read it. No, I would recommend that it say upon the board determining to take no action on a filed document, the board shall not disclose the existence or content of the document absent compulsion of process or the order of a court of competent jurisdiction. Which is basically saying, once the board has reviewed it and they're not going to take action on it, the board is not, no member of the board and the board is not going to reveal or release any of the information that was in that document.
So are we looking for a motion to make that as,
I leave that up to the primary members. If there's a motion, then there'll be discussion. And then at that point, the members can decide if they want to approve today or wait and consider the rules until the next meeting.
I would make a motion to approve the rules and the amendment language that Attorney Elman just indicated.
I'll second that.
Any discussion? Supervisor Seaver?
County Attorney Chairman, you see if you would permit privilege of the floor during the time of your discussion. I would have information that would be relevant to the motion for you. If without objection.
Is there any objections from anyone? Any member?
No.
Thank you. Thank you for the opportunity for privilege of the floor to be granted during this time as you weigh out what are very important considerations in front of you today and the rules of the Board of Ethics. I, for one, and for those of you I have not met, my name is Rachel Sieber. I serve on the Warren County Board of Supervisors and had the distinct honor and privilege during 2021 to be part of constituting and developing the Board of Ethics that is before you, thereby establishing the board itself. It's a really exciting opportunity to see all of you here. I recall 2014 when I took my first oath of office here in this room and filed my first Board of Ethics financial filing disclosure, which I later learned was put into an envelope, sealed, and only unsealed upon request of a violation. Since that time, I have watched that process be abused, frankly, and not utilized in a way that could be beneficial to all members of the community and to members of the board and to employees of our county. It's been critical to have an active Board of Ethics committee and alternates for the past decade. So it's really exciting to see all of you here, and you are owed a huge debt of gratitude for your efforts, saying yes, being here voluntarily, and recognizing that you're already an hour and a half into your meeting. I agree with Attorney Elman when he earlier said, as I watched on YouTube, a sea of change. And that is exactly what occurred in 2021. My concerns with the rules that are before you today and not tabling these to discuss in further detail or consider the public's or other members of the board here before you or employees' concerns about these rules may in fact be that there are some concerns and considerations that could be made and put into effect by all of you. Of course, it could be amended, but I do see that on page I'm sorry, I just pulled it up and I just started to take a look at these. I think they were released on Friday. But on page 2, understanding rules and procedures, section 1, subsection I, it says the board may use Robert's rules. I would request that you consider the language of shall, because of course, shall, we all know means we've got to do it, right? Should is we'd like you to. So I know none of us need a lesson in our vocabulary, but to me, that's a really, really important difference. And so when it says you shall use Robert's rules, it means we are going to conduct ourselves here in Warren County with professionalism, with respect, and with due process. And I think using Robert's Rules of Orders is something that the board has used of supervisors. It's one that many of our entities use. And I am sure that the Warren County Board of Supervisors through the clerk's office can provide you with a Robert's Rules book as well, which is very helpful. One that we did order back in 2021 for all our members of the board as well. So it is something that gives us all the same playing field so that we know where we stand when we are asking for privilege of the floor or for a motion to be tabled or seconded or discussed. So that was one suggestion I had before you approve these rules here before you today. And many of you sit on boards, I am sure, that already do follow Robert's rules, and you are probably much more of an expert than I'll ever be in them. The other concern I had, and I quite frankly have several, which I am happy to submit in a form of a memo to the chair and the vice chair. And by the way, congratulations, Mr. Vice Chairman and Mr. Chairman here today. That would provide a few more questions regarding or considerations that you might be interested in just taking a look at. Having been an integral part of forming this law and this board that's here before you today, I do have concerns. One being what you just spoke about when someone is accused of an ethics violation. I am sure none of us take that lightly. It's an incredibly serious allegation, but it is one where we are continually, if we are continually accused of such violations, it doesn't seem right, I suppose the word might be, or fair, to not notify the person being alleged. Now, it may not be a sworn affidavit that's submitted to you, so it's not considered to be real and thrown out. It may not be signed by the complainant. Again, a tactic that may be used so that you continue to hear information where perception becomes reality, but in fact is baseless. It can be used in an effort to stalk, to harass, to annoy, and to alarm. Once again, not something that I think we should take lightly, but I do believe that there is a process that should be considered and one of due process. I don't necessarily believe that just because a determination is not made, that you shall not be afforded an opportunity to notify the person that is being complained about. It may or may not come as a surprise to you that many of us in office who all are hopefully here fighting the good fight and continuing to try to make a change, a positive change in our community, often come under attack, come under the impression that we aren't doing those things for the right reasons. So I have no doubt that you have a plethora of complaints against me in front of you that may or may not constitute legitimate complaints. That being said, I always would advocate for the person being accused of those complaints, or of course, the person accusing, having an opportunity to be notified, even if it is pushed to the side and that complaint only is provided to the person that was complained about, if that makes any sense. It just seems to me that as that pattern of behavior continues, it may cross over different thresholds where those behaviors may in fact warrant other types of sanctions, whether it be civil or criminal sanctions. And these complaints that are being filed, in my opinion, once again, are incredibly serious, as I know we're all here to do the right thing. In that light, I also have had an opportunity to look at many other Board of Ethics websites in different counties, and I would encourage you to do the same if you haven't already. Many do post different procedures that are going on, the contact information of Board of Ethics members, ways to communicate. I hope that you'll all be set up with all those identifying emails, which brings me to my next concern that's not here in your packet, but just that you should be issued a county email, not only to complete your Board of Ethics training, which I'm not necessarily seeing where you review the list of people who completed their trainings, and send those letters reminding them that perhaps they've forgotten to complete their training, particularly with their county email address. But as it relates to the opinion on a conflict. And while I am definitely going to put some of those concerns to you in writing, so again, I'm not here before you today for the next hour citing some different concerns and questions. I do want to bring up to you regarding the opinion, and there's a practical piece to the request for an opinion from this board. In the past, it used to be where if we had a question on whether or not we could vote on something, and I'll give you a very real example, one where the college was before us. I teach college, I teach for SUNY, I do not teach for SUNY Adirondack, but a decision came up, a debate in committee on funding to SUNY Adirondack. Well, there was an allegation made, probably one you'll read in an ethics complaint, or one that you'll throw out because it's not a sworn statement. I assume, but regardless, if it was a sworn statement, I would hope you'd have me provide you with a copy of my paycheck. That would answer your question. I doubt the person complaining would have a copy of my paycheck so that you could see I'm not employed by the college that we're debating. But the community college, the discussion came up on funding and changing the formula. And an accusation was made that perhaps I shouldn't debate on it because I'm an employee there, but I'm not. And so I go to our county attorney and say, I'd like an informal opinion, but this doesn't designate between informal and formal opinions. I'm concerned that if every time I have to come or another member, which they should, come to you and say, I have a conflict. Perhaps I have a conflict on voting, even on members of this board, because my town board might have a considerable interest against a member of the board. How do you go and make that request for an informal opinion? How do you ask for an formal opinion? And if that formal opinion takes 90 days, ladies and gentlemen, that decision at the board level has already come and gone. That debate on the college has come and gone. And while we may have additional debates, at the time I was afforded an informal opinion by our county attorney because this board was not constituted. Had it been constituted, I would have waited up to 3 months perhaps to get an opinion back on whether or not I could debate, because I wanted to be proactive and ask. Now, I know in my heart of hearts I don't have a conflict, but because I come under constant scrutiny, it was important for me to ask for it. I'm sure like all of you want to make sure you cross your T's and dot your I's. So I would just ask that our county attorney still be afforded an opportunity to provide informal opinions that happen in an instant on the board. There are times things come up that we don't even know are coming up because they're off the floor, but there's a conflict or a potential. In your reviewing our financial affidavits forms, and I hope that, prior to this being constituted, those forms were about 30 pages. We're very excited that now before you in your review, it's just several important pages, but only a few. That you're looking at that to make a determination. Is there a likelihood that this person has a conflict? Look, she works for SUNY Plattsburgh, but she doesn't work for SUNY Adirondack. Therefore, that's not a conflict. That's an easy one to go back and look at. But if you could do it electronically, you've all taken the oath of office. You are all to be trusted. This idea that it can only be given to you in paper format is a little bit of a foreign one to me, but it's one that I understand has been a sensitive issue. So I think there's a lot of things within your rules that perhaps could be tweaked or modified or looked at a little differently. And I have full faith and confidence that you will. But before you vote on them today, those were some of the issues that I just wanted to personally appear of course, one, to thank you. I am thrilled to see you here. And two, to recognize the hard job that you have in front of you. And I think these opinions that you give, the review of our affidavits and the hard work that you're going to put into recommending changes on our Warren County Board of Ethics is top priority. And I hope that shows. I wish there were 20 supervisors sitting here telling you thank you. And I am sure that you will hear from all of them to thank you for your hard work. But these are just a few of the concerns I would have about the information that's before you today. I would appreciate your consideration. And again, I very much appreciate your time and the opportunity to be heard. Thank you.
Thank you Supervisor Seaver. We do have a motion. Do we have any further discussion on the rules? So moving forward, we would look for a vote on the standing rules as described this morning and in detail by Attorney Elman. Thank you, Larry, for putting all the time into it. With that said, all in favor, say aye.
Aye.
Aye. Any opposed? The rules carry.
I would just like to say that I think, right, we still have the opportunity to amend these based on some comments from Supervisor Seaver or other people, correct?
Yes, we do.
Am I correct in that? So
Yes, absolutely.
we still can take the advisement of other people or supervisors.
Definitely.
Moving forward, the proposed agenda for the next meeting. At that time, I believe, Larry, you probably have an abundance or you have some complaints that need to be looked at.
I have documents that have been filed with my office that I would like to get in front of the board for that initial determination on what they are and whether they constitute an ethics complaint. So there's two parts to that. Part one would be when the board is able to schedule its next meeting. And the second part is in what format or manner do the board members wish to receive those complaints, those filed documents before the next board meeting? Those would be the two questions I'd ask the board to consider.
So first, should we set a meeting for a date for the next meeting? We're here Monday at 11 o'clock. If we are looking to address something in the next few weeks, is that sufficient?
If we could do it within 2 weeks, that would be great. I would like to be able to put this in front of the board so they can work through it before February 1st, which the focus will most likely start to shift toward those financial disclosure statements.
So we will look for the 23rd at 11 o'clock.
That's a committee day, so
And there will be committees.
23rd and 24th.
They're doing committee meetings on that Monday and Tuesday.
Okay.
We'll do the week before it, by any chance possible.
That's
The week,
holiday.
next week?
I mean, the Monday.
Yeah, like even the 19th, the 20th.
Mr. Chairman, can I ask a quick question? I think if I'm understanding the rules correctly, alternate members are not supposed to comment until public comment period. Is that correct?
That would be correct.
Okay, so if I wanted to discuss any of the things we've talked about until this point, I should wait until public comment.
Yes, and that does not necessarily apply to executive session, but it would apply for the open meeting portion.
Okay, unfortunately, I have to go because I have a city meeting. I know we talked about trying to keep this meeting
Yep.
to an hour and it's a little longer, so I'll try to bring my questions to the next meeting.
Thank you.
So.
Did we determine, before you leave, did we determine that when we're gonna meet next?
We have not. So it's not available the 23rd and the 24th, Wednesday, the 25th.
Well, the question I have to that is if we have things we're gonna have an action on. And you want it before February 1st, does that leave us enough time to have a follow-up meeting if we need to?
I'm open for,
I think just having an initial meeting will be very important, and then the board can determine what actions, if any, they need to take, and then it's going to be kind of part of the regular flow where you're going to be doing more than one thing at once. But I'm hoping for one meeting in January where we can just focus on documents that have been filed with my office since the last board was dissolved. So whatever day the board decides.
are there any days that work for anybody any better than any others?
Fridays are not good for me, but
Okay.
Tuesdays are not good for me. I mean, I can
Can everybody do Wednesday, the 25th?
18th or I could do the 25th.
And we can do the 18th too. If it's an open day for people.
Not around.
The 18th, I have a meeting at 10, 11 o'clock.
I can't make the 18th.
Okay.
Can we do the 25th?
25th?
Yes.
Are we doing it at 11? Is that, can we do it sooner?
Yeah. One of the things that I had there was a discussion that 9 o'clock was too early for someone. And we decided on 11.
That was just for Monday. We have a team meeting for my company on Mondays at 11, at 8 o'clock. So the 9 was,
I would think a better time would be 10. And then if we run over, we're not,
that was just for me on Mondays,
Okay.
but
Well, when you do a 9, that's even better.
yeah.
Earlier the better, as far
Yes.
as I'm concerned.
9 o'clock on the 25th,
I can do 10 o'clock.
10 o'clock on the 25th.
And if we're gonna reserve 2 hours for that meeting?
Okay.
And I base the 2 hours on, I believe it'll take an hour, which means it'll be about 2 hours.
makes sense.
10 a.m.
10 o'clock.
10 a.m.
And the next question you had, Larry, was with respect to how to deliver the documents.
Yes,
Is email sufficient on the county email that's been established for everyone?
I would say on most things, I would say email's fine with me. Yes.
Email fine,
mhm,
email.
okay,
I-
so I will do my best, at least 1 week prior to the meeting date to have an email out to every member. I will meet with the chairperson as far as what will be in that email. As far as what file documents we'll get out. But hopefully everyone will have at least a full week.
And that'll be the information that we're reviewing at that meeting.
Potentially, yeah. That's gonna be up to the board to decide. Okay,
So I'm gonna have one more question for the next one. So what about the past complaints that were looked at or reviewed when the previous board was not successfully or sufficiently constituted? Were they gonna be looked at again, or?
no, nothing, the documents that I'm sending out are all documents that were received after the last board was disbanded.
Which was when?
I don't know the date off the top of my head. I want to say maybe May, June,
I think May or June. right around.
might have been June, but I'm not 100% sure. I'm gonna say it was July 15th when the current code was enacted, July 15th of 2022. So,
All right, so we have a meeting set. The next thing would be a privilege of the floor, public comment. Hearing none. I would make a motion to, I would look for a motion to adjourn.
Mr. Chairman,
I'm
I,
sorry.
not public comment, but I would like to talk about how we're going to receive the ethics forms to
Yes.
see. That was something that's supposed to be determined. So right now, it looks like on or before the 14th of each calendar year, we're supposed to conduct an initial review. That doesn't necessarily mean a meeting, but how you had mentioned that in the past, you're concerned about them getting out or whatever. my thought was, I like paper.
Mhm.
Could we get? Because if it's gonna be filed by January 31st, that doesn't leave a lot of time. If we could get a binder that we sign out. That we can review, utilize, and then return back to the county attorney after the fact, so it is not out in the public purview. To me, that would kind of work both ways, so we can use it. Once we're done with those binders, return them back. I don't know if that's something that people like that idea, because honestly, if you email them to me, I'm gonna print them out anyways. Make my notes and do my thing if I have comments. So I don't know what anybody else thinks, but. I would just as soon have something in my hands to review, and if I gotta return it for safekeeping, that's fine.
I believe previously they were put in binders, I think alphabetically. I can't remember how many binders that we're talking in the neighborhood, probably of 100 or so more people that are obligated to file, so there's quite a bit. And I think the procedure the last time was to make an appointment with the county attorney's office and review them. I don't know if we check them out of the building. We put that out. I mean, that's,
I don't mind working it like a library in a way where we check it out, check it back in, and we make sure that they're back for the next person to look at. It's a lot of paper. It's a lot of paper. I don't remember exactly how many pages. But it's definitely a lot of paper.
Yeah, I'd like to, personally, I'd like to have them
Yeah.
like a weekend where I can review them and spend some time and make notes and do whatever I need to do. I don't mind returning them, but
sure.
Yeah, I don't think, we can even do that with the filed documents rather than sending them out by email. We can do paper copies if anyone lets me know in advance, do you want to pick up a paper copy for review? Just let me know after the meeting today.
are most of these very thick? Are they lots and lots of paper?
No, for the next meeting, it's not anywhere near where the
Okay.
financial disclosure statements are.
Yes, sir.
Thank you. I would just like to comment that with the ability to send a file that's encrypted and whatnot. I would be an advocate of not having to travel so much, being that I have to travel enough as it is. To be a good steward of documents and information, and if you do print it, shred it after you're done with it, or. Just have an encrypted type file sent with a password protect, kind of like a bank does.
Yeah, I think we'll work it out at the next meeting. We'll make sure that we're all on the same
Seems to
page.
be there's different methods we could do it by. Whatever is easiest and restricts to the confidentiality, I think works. Any further discussion on any other topics?
Can we, I'm sorry, I'm
No, not at all.
monopolizing, but can we look at scheduling that? We have to review the documents by the 14th, but we don't necessarily have to meet by the 14th. As I understand it. Is that correct?
I would recommend that you do a meeting somewhere around that date of the 14th, it's a Tuesday.
I'll be honest, I'm traveling until the 18th. I'm gone that week, so I'm just trying to figure out how I can make my schedule work for everything.
I believe that date, because no action occurs outside of a meeting. So you can prepare for a meeting, but no actions occurring outside of a scheduled meeting. So I'm just checking the code. So there's no need to meet by the 14th.
Right.
But no action is going to be taken on any late or missing submissions until the board can meet to vote on it. So I would recommend scheduling something that week, and if a member can't be here, luckily we have alternates to help fill the gap. Because no notices will go out to individuals who did not file until after the board directs that to occur, which is supposed to occur by the 14th, I believe.
First.
No, the first is the
August.
Yeah, in theory, if my office could assemble, put together, provide, we can't do that in a day. So the 31st is the last day for filing, which is a Tuesday. So if the board wanted to schedule another meeting around the 14th, that would help in getting out notifications after that meeting, if needed.
Is that something the board wants to do at this point? Schedule a meeting for February to review the document?
My recommendation is we put something on the schedule, so this way we have a tentative date.
If we look to schedule something the week of the 6th, is that Larry, is your office able to get those documents at that time?
You guys will not have the chance to pick them up, review them, or to receive them electronically and have a thorough review by the 6th. Maybe by the 10th, but not by the 6th.
Yeah, I think.
How about the 9th?
What we'll be able to do by that day is you'll know who's filed and who hasn't, and be able to direct the notice to go out. Whether you'll have enough time to do the initial review of all of the statements, that might take you a little longer. So if you wanted to do the 9th, that would be fine.
How's everybody set for the 9th?
Doesn't work for me. So
I've got a physical at 9:30.
Pardon me?
I've got a physical at 9:30.
You look good.
No.
So the 9th is 9th in the afternoon?
I'm even
work?
good after 10:30. It's just 9:30 to
Okay.
10:30.
The 9th, say at 2:00? It'll look like we do the 9th, we'll start a meeting for the 9th at 2:00 as well.
Yes. Mr. Chairman, please ask an alternative. Behavior. I will not.
Thank you. Any further discussions or any other things that need to be talked about at this point? I would look for a motion to adjourn.
I'll make a motion. I'll second.
All in favor?
Aye.
Any discussion?